Now let's address another issue concerning Judge McAvoy. How he likes to continue fixing cases against me. In 2003, I filed a lawsuit against Judge Judge Kaye, Chief Judge of the Court of Appeals. I had made my arguments before the Court of Appeals when I got convicted of spraying the Court of Appeals with chicken manure. I was denied my right. I never right to counsel in the grand jury. I was denied. I never signed a waiver of immunity and submitted it as required because they've already stated on the record, and I have the transcript, that it was never submitted as required. I was entitled to judicial immunity, that they changed the law prior to my spraying. The appeals courts had held that where you just had to clean something up and there wasn't physical damage to the property, that wasn't criminal mischief. There is no definition under New York State law for criminal mischief. In my case, they determined, well, cleanup costs are now criminal mischief. So they changed the law. I raised these issues to the Court of Appeals. Court of Appeals, Judge Judge Kaye threw it out. Problem is, Judge Kaye had absolutely no authority to dismiss my appeal. She was deprived of all jurisdiction, and I will explain why. Statement of subject matter jurisdiction. The court had jurisdiction pursuant to 1983 section. I was deprived of my rights under state law and federal law of due process and equal protection of the law. The Court of Appeals has jurisdiction to hear this matter pursuant to this as I filed it timely. This is what I filed to the Court of Appeals after Judge McAvoy threw out my petition without addressing any of the issues, without allowing me to respond. They didn't even have to respond. It went even before it got before them. Statement of issues presented. Was the defendant disqualified by operation of law from ruling on appellant's motion before the Court of Appeals? That was Kaye. Appellant is me. Was the defendant acting within her judicial jurisdiction? Absolutely not. Is the defendant entitled to immunity for her actions when acting in face of clearly valid? The case law is, where there is state statute or case law that expressly deprives the judge of jurisdiction, judicial immunity is lost. In other words, they got to have some authority. And if there's law that says they can't do something, then they lose their immunity. Case of statement. The appellant filed his complaint against the above-named defendant, documented that the defendant was acting under color of state law and that she was deprived of jurisdiction to rule on his motion before the Court of Appeal as she was disqualified by operation of the law. The appellant had a constitutional right to have his matter heard before an impartial judge. There is no such thing as an impartial judge in New York State. Now, defendant had a personal interest in a case. If a judge has a personal interest in a case, they cannot rule on it. The reason being she had a personal interest. All state property in the New York State is under the exclusive control of the Offices of General Services. They take care of all the state property in the state, except one. Yes, the Court of Appeals. Defendant did not have authority to rule on appellant's motion as she had a direct interest in the proceeding pursuant to Judiciary Law 60. The Chief Judge of the Court of Appeals shall have supervision and control of the Court of Appeals building in the City of Albany with the grounds and premises adjacent or apparent thereto or connected therewith belonging to the state, so far as such grounds or premises now and hereafter shall be laid out and completed. It's like, give you an example. You go into, you rent out an apartment. You're getting evicted. You walk in and guess who the judge is? The building manager or the owner of the building. They would have to disqualify themselves. They have a direct interest in getting you out of the building or out of the apartment. Same thing here. When I sprayed the Court of Appeals, that was under her supervision and control. She has an interest in it. Disqualification of judge by reason of interest, or a judge shall not sit as such in or take any part in the decision of an action, claim, matter, motion, or proceeding to which he is a party, or in which he has been an attorney of counsel, or in which he is interested. Don't tell me Judge Kaye was not interested in my spraying of the Court of Appeals building, being the chief judge and the building being under her supervision and control. So had an interest in the outcome of the proceeding as the court is under her direct supervision. However, a justice or judge who is disqualified from presiding over a motion under judicial law lacks jurisdiction to decide the issue. Jurisdiction cannot be obtained by consent of the parties. Well, I never consented to her hearing it anyway. Or by failure to object if the disqualification is under Judiciary Law 14. You don't even have to object. I didn't even know she was the one assigned until I got the order dismissing my motion of habeas corpus to get out of jail because of my rights being violated by the liberal Democrats in Albany County. Johnson, for example, a judge shall not sit in or take part in any decision, action, claim, or matter in which he is a party or in which he has been an attorney or counsel in which he is interested. This is sole statutory authority in New York for disqualification. If disqualification under the statute were found, prohibition would lie since there would be a lack of jurisdiction. There is an express statutory disqualification. That's very clear. She didn't have the authority. Ruling on Pelhams was a denial of due process. Judge McAvoy refused to address the issue of whether or not she had the authority and address Judiciary Law 14. He just took the position, she's a judge on the Court of Appeals, therefore she had the authority. This is how Judge McAvoy fixes cases. Tell me how many other cases he has fixed in this state. I know he's fixed every one of mine that he's gotten. He's fixed others. He doesn't care about constitutional. His job is to protect the corrupt judiciary, both state and federal. The defendant's ruling on my motion was a denial of due process and in violation of Judiciary Law 14, as she had an interest in the building that I sprayed with chicken manure, trying to enforce the constitutional rights of mothers, fathers, and children in this state, about the illegal imprisonments, the denial of due process, these closed court, family court proceedings, denial of jury trials, courts of proper jurisdiction, and a host of other things. Defendant was not acting within her judicial jurisdiction, as case law and state statute clearly hold that she had no jurisdiction to rule, as she was prohibited by law from hearing the matter because she had a direct interest in the outcome of the proceeding. Defendant was acting in complete absence of all jurisdiction. McAvoy, why doesn't this apply to him? Issuing a false certificate. A person is guilty of issuing a false certificate when, being a public servant, authorized by law to make or issue official certificates or other official written instruments, and with intent to defraud, deceive, or injure another person, he issues such. That's exactly what he did. Stripped me of my rights. Now, in his order, in his decision and order, he states, In his complaint, Collins claims that his constitutional right to appeal the denial of his habeas corpus petition was violated by defendant Judge Kaye, Chief Judge of the Court of Appeals. Plaintiff claims that because the Chief Judge is charged by New York law with the supervision and control of the court building, Chief Judge Kaye had an interest in the outcome of the proceeding and therefore was disqualified from ruling on plaintiff's request by operation of law. Then he says, for a complete statement of plaintiff's claims, reference is made to the complaint filed herein. And then he states, the law of this circuit, which is totally false, and I'll get into that in a minute, judges enjoy absolute immunity from personal liability for acts committed within their judicial jurisdiction. The absolute immunity of a judge applies however erroneous the act may have been and however injurious in its consequences it may have proved to the plaintiff. That's not what the federal U.S. Supreme Court and other circuits and the Second Circuit have held. They have all held the judges have to have jurisdiction. I've demonstrated she didn't have jurisdiction. She was disqualified by operation of the law. Fields versus Soloff, 920 Federal 2nd 1114, Second Circuit, 1980. Second Circuit covers New York State. Moreover, a judge will not be deprived of immunity because the actions he took was in error, was done maliciously, or was in excess of his authority. Rather, he will be subject to liability only when he has acted in clear absence of all jurisdiction. She acted in clear absence of all jurisdiction as there was state law that specifically deprived her from ruling because she had an interest in the case. Mastry versus Jakovsky, 850 FD 2D 50, Second Circuit, again 1980. The courts, however, have made a critical distinction. A judge who performs a judicial act in excess of his or her jurisdiction is immune from civil suit. A judge who acts in clear absence of jurisdiction is not. When a judge lacks jurisdiction over the subject matter, any authority exercised is a usurped authority. The question, therefore, is whether Judge acted in clear absence of jurisdiction when he entertained complaints and issued arrest warrants when the alleged misconduct occurred in a town over which he necessarily and obviously knew he had no jurisdiction. Judge Kaye, as Chief Judge of the Court of Appeals, and this enlightened soul, as the liberal Democrats want to call her, knew she had no authority to rule on my motion. She doesn't like it that I've won several times demanding constitutional rights, that she sits there and tells everybody these are not substantial rights in New York State. They need to be, they are. We need to get rid of these judges like Judge Kaye, a two-bit, lying, arrogant whore of a judge who has no respect for anything. Every person under color of any statute, ordinance, or regulation, any statute, customary of any state or territory, subjects or causes to be cited any person insuring thereof to the deprivation of any rights. This is the problem. They don't want everybody that's been involved in family court suing these judges in the state of New York. It's cover up, cover up, cover up. Federal crimes. Tell me these federal judges are not guilty of these. Conspiracy against the rights of citizens. If two or more persons conspire to injure, oppress, threaten, or intimidate any citizen in the free exercise or enjoyment of any right or privilege secured by him by the Constitution or the laws of the United States, or because of his having so exercised the same. Judge McAvoy was conspiring with Judge Kaye and the attorneys and everything to fix the case in her favor. Just like the appellate court judges. Pierre N. Laval, Jose Cabranes, and Robert T. A. Katzman. He's been on a few of them I've seen. You know, These guys are supposed to be protecting our rights against the corruption. Instead, they're promoting the corruption. They all belong in jail. They're terrorists. Kaye was a terrorist. McAvoy's a terrorist. These three judges are terrorists, and every one of them is a traitor to the United States Constitution. They need to be removed from office. The U.S. Senate needs to hold hearings on what these judges are doing in stripping people of their constitutional rights. One other issue. I forgot to read the Court of Appeals ruling. That's the United States Court of Appeals down in New York City. And in their order, affirming Judge McAvoy's order dismissing my complaint, they state, Chief Judge Kaye had issued an order denying plaintiff's motion for leave to appeal the denial of his habeas corpus petition by the Supreme Court Appellate Division, 3rd Department. The substance of plaintiff's 1983 claim is that, as an official charged with the supervision and control of the court building, under New York Judiciary Law Section 60, and as a person allegedly affected by the smell of the manure, Chief Judge was disqualified from ruling on plaintiff's motion. That's true, both of them. Then it goes on to state, the court then dismissed plaintiff's claim as frivolous because this circuit law grants judges absolute immunity from personal liability for acts committed within their judicial jurisdiction. And because Chief Judge Kaye had jurisdiction to deny plaintiff's motion, emphasis in internal quotation, plaintiff appeals from the district court dismissal of his claim. We have considered all plaintiff's arguments and find them without merit. They love putting that without merit. Explain to me how Judge Kaye had jurisdiction when she is basically the de facto owner of the Court of Appeals building because it's under her supervision and control. That disqualified her under judiciary law as she had an interest in it. These corrupt Court of Appeals judges have also been holding your right to a public trial, your right to a jury trial, your right to a court of proper jurisdiction, and the other statutes I've raised. They don't care about it. They don't care about people's rights. All they do is care about protecting the corrupt judges and seeing how much they can screw the citizens of this state over. New York State is a communist state. It's a socialist state. They do not believe in rights. Any civil rights. They're all talking about civil rights. They only believe in civil rights when it's to their advantage. Otherwise, you're not entitled to civil rights in this state. And these federal judges, they're supposed to be protecting us. Pierre Laval, Jose Cabranes, Robert T. A. Katzman, circuit judges. They're a disgrace. They're traitors to the Constitution and the laws, federal laws and state laws that they are supposed to be upholding. Can you just imagine the fallout there would be if the U.S. Court of Appeals ruled that Chief Judge Judith Kaye of the New York State Court of Appeals was issuing an order over which she had absolutely no jurisdiction? What that would do, it would make her the laughing stock of the judiciary, that she doesn't even know her own jurisdiction. That's one other reason they don't. It's protect her, whatever. Instead of protecting the people of the state and protecting my constitutional rights, the due process and equal protection.